Hello, friends, and welcome to another week of The Legals with Kate. Now, this week, we're going to talk about a form of immigration relief called cancellation of removal for non-permanent residents. So that's somebody who is essentially somebody who's been in the United States for more than 10 years. And first of all, they need to statutorily qualify, but they're not somebody who has their green card and they've been waiting on naturalization. So this is generally somebody who has been in the U.S., doesn't have their papers, and they've been in the U.S. for more than 10 years. There is this exception to deportation called cancellation of removal. Now, there's a must-haves aspect of it, and then there's the discretionary. So first you need to be what they call statutorily eligible. So the things you must have before the judge can even consider whether you are somebody that should be in the United States. So most important thing, though, to remember about cancellation of removal is it is a form of relief from deportation or removal. Now, deportation and removal mean the same thing. But what it means, what that term means, that it's a form of relief from deportation or removal, is you can only apply for it if you are in the process of being deported. So a removal or deportation case has to have been opened against you. So you already have to be in removal or deportation proceedings before an immigration court. So people generally do not want to proactively apply for this because that means you would have to say, hello, ICE, I'm here illegally. Can you please put me in deportation proceedings? Now, generally how somebody does end up in deportation proceedings is either A, they had an encounter with law enforcement and law enforcement notified ICE that you were here illegally, or if you apply for some type of status and your status is denied, then Citizenship and Immigration Services could also notify ICE that here's somebody who's in the United States, they don't qualify for anything, put him in deportation proceedings. So, again, most people don't want to proactively apply for cancellation of removal because it's risky. If you've already been here for a long time, ICE has not gotten you on their radar, why would you want to say, look, ICE, here I am, please put me in deportation proceedings, and then I risk not being able to stay in the United States? Because, again, part of it is statutory, so there is the must-haves, and then part of it is discretionary. And since there's this discretionary aspect of it, you can have no idea in advance whether the judge will or will not rule before you. Now, I can tell you, from having worked all over the United States in the different immigration courts, every judge is different, every jurisdiction is different. So it is a very risky prospect to purposely place yourself in deportation proceedings. So let's say you ended up in deportation proceedings, and so you already have appeared in immigration court, and you're in the process of trying to stop the deportation. So first, to qualify for cancellation of removal, again, the must-haves, you must show that, 1, you've been 10 years in the United States, and you have to have been continuously physically present in the United States for at least 10 years. Now, this 10-year period is measured from the date of entry until the date that ICE issues your notice to appear, or in other words, the summons for immigration court or the paperwork that says you've been placed into deportation proceedings. So the notice to appear, or the NTA, is the slang for it. So the date that you entered until the date that the NTA or the notice to appear was issued, that needs to have been 10 years. If it was 9 years and 180 days, it's not enough. It needs to have been 10 years. And during those 10 years, a single absence of 90 days or several absences totaling 180 days will interrupt that continuous physical presence. So what that means is, even though it says continuous physical presence, There are a lot of people, for example, that live in the southern border states that will go back to Mexico for the death of a family member or a quinceañera or something like this, but they leave and they are able to come back in. So if they just go for short times, and they haven't consistently gone for those short times, and so it doesn't add up to 180 days over the last 10 years, you are still eligible. Now, the key is when you leave and come back, you cannot have gotten caught. So if you come back into the United States when, at year 6, and as you're crossing in, you are stopped by immigration, you're given a notice to appear, and you just don't show up, your time stopped at that mark where you didn't show up. So let's say you're coming through the southern border through Texas, but you're living in Chicago. You got stopped in Texas. They processed you. They released you, gave you your notice to appear, and you disappeared into Chicago, and you didn't come to the attention of ICE again for another 5 years. Yes, you've been in the United States for more than 10 years, but that notice to appear was issued after 6 years. So at 6 years, your time stopped. So even if you're here for another 20 years, that time stopped when you were given that notice to appear. Now, okay, so there are people who leave and then they're able to come back in undetected by ICE in different ways. And or let's say you haven't left at all and you've been in the United States for 10 years. You entered, you've been in the United States for 10 years, you never were put into immigration proceedings, you are never given that notice to appear. That's what you have to prove. You've been here 10 years. Now, it's not particularly easy to prove those 10 years because you first have to show how you came in. One popular way to show how you came in is some kind of maybe some bills from a doctor, or you enrolled your children in the school. Children themselves, if their parents brought them over when they were 2, and if you can show your school records for the last 10 years, that also shows that you've been continuously present. So you can't just say I've been here for 10 years. You have to find different ways to document that you've been here, be it bills, loans, school records, medical records, different things like this that can show that you've been here for 10 years. All right, so that's the most difficult thing, is show the 10 years. Children actually have an easier time showing it because, as I said, if you're brought in as a young child, your parents brought you to the doctor a few times, they enroll you in the school, you go to the school your entire life, you graduate from the school, that shows that you have been here for 10 years. But some kind of documentation, paperwork, bills, loans, medical records, food stamp records, tax records. These are all popular ways to show that you've been here for 10 years. All right, so the second thing that's required to be eligible is that you have good moral character during that 10 years, which means that you don't have, first of all, a felony conviction. Now, what constitutes a felony conviction is, that's actually not a straightforward answer either, because every state has different laws in terms of what it deems as a felony. So, for instance, in one state, possession of meth at all is considered a felony. In another state, possession of methamphetamine below a certain amount is not considered a felony. So it has to be felony by federal criminal law standards. So again, felony under state law does not necessarily mean that you are ineligible for cancellation of removal. So you can't have been convicted of certain criminal offenses that would render you inadmissible or deportable. And the last thing is, you have to show that there would be exceptional and extremely unusual hardship to a U.S. citizen, spouse, child, or parent. Now, that's also a very important aspect of the elements of cancellation of removal. Exceptional and extremely unusual hardship. Now, having worked with ICE for a long time, I can tell you what is not considered exceptional and extremely unusual hardship. And again, it has to be to a U.S. relative citizen. So it has to be your spouse is a U.S. citizen, your child is a U.S. citizen, or your parent is a U.S. citizen. It cannot be uncle, aunt, niece, nephew, sister-in-law. It has to be spouse, child, or parent. Could you have married the person after you entered the United States? Yes. Could you have married the person in year 9 of the 10 years? Yes. But it has to be a U.S. citizen, spouse, child, or parent. Now, let me get to what is considered an extreme and unusual hardship to the U.S. citizen relative. What is not an extreme and unusual hardship is something very popular is, oh, my child has asthma. And if I were to go back to my home country doesn't have the medical care that they would get in the United States. Therefore, it's an extremely unusual hardship. This actually, in vast majority of immigration courts, is not considered extremely unusual hardship. And not to sound cold-hearted, but a large number of people, when they're facing attempting to get cancellation removal, the two most popular reasons they cite as to why they cannot go back to their home country is their child is a U.S. citizen and has a learning disability and asthma. Two most absolute popular claims by people stating extreme and unusual hardship, and obviously it's not extreme and unusual when a large number of people make that claim. Plus, people can get perhaps not the same level of care in their home country, but they can still get care back in their home country. Now, something else that people will try with the extreme and unusual hardship is, for example, my children will miss me so much. And the psychologist writes a letter saying these children will miss their father so very much if he gets deported or removed. Again, it has to be an exceptionally and extremely unusual hardship. Now, hopefully, every child will miss their parent if they get deported. And since this is the normal part of what happens when a parent gets deported, it is not exceptionally and extremely unusual hardship. Now, things that I have seen that do count as exceptional and extremely unusual hardship, I had a family whose child was born, when the child was in the womb, they started the process of a twin, but the twin, it just started the process. So when their little girl was 6 years old, they discovered that this other twin had created tumors, if you will, but severe medical issues to the U.S. citizen child, because there was the other child's part of the other child's scalp had grown inside this 6-year-old's body, so there was like masses of hair in the internal organs of this child. Now, obviously, that's something that is an extreme and unusual, that it would be doubtful that they could find the proper medical care to take care of that back in their home country. And it was going to take a long time because the child was only 6 and multiple surgeries over a number of years. So that judge granted cancellation of removal. Would every judge? That's hard to say. And again, that's why cancellation of removal is so risky. You would hope that every judge would have the compassion to say this child needs her parents in the United States, but that's not always guaranteed. Now, another extreme and unusual hardship that people will bring up is, oh, the father is a sole breadwinner. Again, everybody brings that up. Of course, if the breadwinner is deported, he's not making money, but that's generally not considered extreme and unusual hardship. I have seen some instances where that actually is determined by that judge to be an extremely exceptional, extremely unusual hardship, but it is rare. It kind of depends on the jurisdiction. And it also depends on Why is the spouse that is staying behind, why can't they work is one of the questions some of the judges will ask. So, for instance, if the child is paralyzed, if the mother is paralyzed or something like that. So it really is up to the judge to determine what is exceptional and extremely unusual hardship, but which makes cancellation of removal risky, especially if you're in certain jurisdictions. But if you're being deported or removed, again, they both mean the same thing, it's worth looking into, because if that's the only thing you have to apply for because there's nothing else open to you, go ahead and apply for it. If you can show that you've been here for the 10 years, then try to convince the judge of the extreme and unusual hardship, because the alternative is getting deported or removed. So it's worth a try. In some jurisdictions, some arguments are more successful than others. The ones that very rarely work are asthma, learning disability, I'll miss my parent, and who's going to be the breadwinner. But that's not to say you shouldn't try if it's the only option open to you, because you never know which judge you're going to get that day. And sometimes the prosecutor working for ICE, for whatever reason, they will decide not to fully argue against the cancellation of removal. So hopefully that helps. Good luck, and please do like us and let other people know. Thank you.